Today, we're so excited to talk to Suzanne and Josh, who run the Moskowitz firm, a law boutique focused on trademark and brand protection. And they work extensively in the CPG space, so much so that they work with many of our clients.
They do.
Yeah, so we're really super excited to talk to them today because they're amazing lawyers and our friends, and also another couple that works together. So today they're going to unpack the 5 common mistakes they see brands make whenever they're trying to trademark or copyright their brand. So I'll leave it off to you guys.
Excellent. Let's start with a disclaimer.
All right. So although Suzanne and I are lawyers, our malpractice insurance carrier would like you to know that we are not your lawyers unless we enter into a formal engagement. So what we're going to do is give you some practical tips, but none of this could be or should be construed as actual legal advice.
Excellent. And before we start too, we're going to really focus on trademark law. That's not all we do. We love trademarks because that's protecting brands. That's things like names or logos or taglines, slogans, things like that. Copyrights are also a really important part of what we do, which might have to do with photographs or packaging or software code or your website. So let's for now today know that the focus is on trademarks, but we're always happy to talk about copyrights and other forms of intellectual property protection too.
Oh yeah, you do plenty of that for our clients.
Things you don't know you need until you realize you need them.
Exactly.
Yeah.
So, all right, well, let's kick things off. What's the first common mistake you guys find with brands that need to get a trademark?
Well, in our experience, and this is, this comes up in the food space a lot, but certainly lots of my software clients and, people who are in professional services businesses also have the same problem, which is they fall in love with a name too hard and too fast without realizing that it's a problem. Now, sometimes people think a name is good because domain names, they're available. They might get a domain name. They might just go to the trademark office and search and see that exact name isn't available. But there's a few reasons actually why a trademark might be refused, why you can't actually protect it, or why you may be in trouble if you use it. One is just being too close to another name, which does not mean that it's the exact same word. It just means that there's a substantial similarity such that a reasonable consumer, meaning like a mom in Whole Foods walking down trying to quickly grab something, might think that these two products come from the same source or they're related. So one thing we do is we do some searching to try to determine if there's something that is too close to yours. And it's a good idea to do that searching kind of before you fall too deeply for a name. So that's like the issue of, one reason why it's bad to fall too quickly. The other has to do with something called descriptiveness, which is a name that you love, but it's basically, whether it's generic or it's nearly generic, you want to call, let's say you're starting a graphic design firm, for example, and you're located in Cleveland and you want to call it Cleveland Design and nobody else is called Cleveland Design. Well, you've passed that first bar, but the word Cleveland is descriptive of where you're from, which doesn't make it a strong trademark. And the word design is totally generic. So great, you've fallen in love with a brand that's hard to protect and hard to keep people from copying. So that all falls under, that's all the first falling in love too soon. But that's a lot of problems in one, I think.
So how do you recommend, go ahead, Josh.
I was going to jump to number 2 when you're ready, but
no. I was going to ask, how do you guys recommend that someone figure out what, if there's another name or if it's too generic or something?
So there's a lot of different ways to do it. And the best answer is to call a lawyer who's experienced with it to help you. There are, we have access to a lot of databases that will make it extremely efficient. You could lose a week or 2 weeks of your time searching, or you could call us and we can do it in an hour or two. And it will be able to give you, there's no guarantees with these kinds of searches, but it will save you a lot of time and we'll be able to give you, a green light, yellow light, red light pretty quickly, which is better than, not having the same tools that we have access to.
Yeah.
And
So-
because we work together, I know that you have access to certain sites and certain tools that just aren't publicly available.
Right. I mean, there's subscriptions we
Mhm.
pay for, but
Yes.
we like them and we can use them pretty efficiently.
Yeah,
Sure.
it's just like anything. Like you guys do this day in, day out, so you can be very efficient versus someone like a common problem our clients have is they don't understand that they have to search by class of what the product is. And so they're just like, they put in randomness and then they're like, it's fine. And then they
Yeah.
get in there with a lawyer and they're like, oh,
Yeah, and I can explain that. Let me explain a little bit more about classes because classes almost made our top 5. It definitely makes our top 10. But it's a really it's hard to come up with a 5 because people make so many mistakes. And that's because it's a complicated process, but we do it a lot, so we know. But everything is registered in classes. It's just for ease of searching and sorting. And, you know, a lot of food items are in the class for like prepared grains, which is like a class 30, or in the class for things that are primarily made of fruits or vegetables, which is class 29, or beverages that are 32. But there's also, let's say you've got apparel and you really actually want to sell that apparel. Well, that's a totally different class too. So it is really important when you go down this road to kind of know what your priorities are. You don't need to necessarily file in every class, but you should at least file in the top classes. And that's actually a very nice segue to our next mistake, which Josh can explain.
And the next,
When I say file, what are we talking about filing?
number 2 is actually registering. So when you have a brand, when you have a name that you're using, that's a trademark. You know, it's a trademark from the second that you come up with the name and you print it on something and you sell it or offer it as a service. You know, and so you have a mark, you have a trademark. That comes with some rights. They're called common law rights, but it does not come with all of the rights that you could have. All of the rights you could possibly have come from actually registering your trademark.
Where?
And you do that at the USPTO, which is the United States Patent and Trademark Office. Each state also has a way that you can register certain trademarks and other kinds of things, but the USPTO is the top of the chain. It's the top dog. That's where you want to have your trademark registered if you're living in the United States. Every country has some equivalent of the USPTO, which we can also help you with. You don't need to call an attorney in France and in Spain and in Australia if you want to register your trademark. You know, most attorneys in the United States, including us, can do that for you, you know, in one fell swoop. But when you actually register your trademark with the United States Patent and Trademark Office, you get lots of extra benefits. Most notably, you get a presumption of ownership. It's basically telling the world, you know, I'm in the United States or whatever other country you filed in, and this is my trademark and I own it and I want to have priority rights over everybody else who hasn't filed. You know, a big part of my practice is actually litigation for the firm. And what that means is if somebody's infringing on your rights, someone's copying what you do, you know, I come in and reach out to the other side and, you know, have them stop, whether it's a cease and desist, whether it's a lawsuit that needs to be filed or special actions in the USPTO. And when you have a registered trademark, you get additional benefits, such as additional money that can come to you if the infringement is actually found. Higher dollar amounts, attorney's fees can be reimbursed, those kinds of things. So it's not only important just to tell the world that this is your trademark, but it'll also help you police it as well.
It's also really important with your partners. People want to see it. There's a sense of prestige when you've got that R in a circle. And of course, organizations like Amazon make it really hard to protect your brand on their platform if you don't have a registration, or at least a registration pending and filed. So it's a lot of value that's kind of akin to getting an insurance policy on your brand.
Do you guys recommend that brands always include that circle with the R or the TM or, you know, any of those kind of like legal, because as designers, we are like, I don't know, I don't like to include it, but because it's just aesthetically,
Yes.
but at the same time, like I understand the value of protecting your brand and making it known to the world that you want to protect it. So like, what do you, I mean, just as I guess a general rule of thumb.
The easy rule of thumb is put it on the first or most prominent appearance on a package or a page, meaning a website. Don't
Mhm.
put it everywhere. I mean, it just starts to look terrible. And of course, you can use TM even if you don't file, even if you never file, which we don't recommend. TM just means I am claiming this as my trademark. This is a brand. You're supposed to know that it's a brand. R in a circle shall not be used until you have a registration certificate.
Oh,
Yes.
see, I'm learning things today.
Well, we learn and we get confused, so it's good to clarify.
Yeah.
There's a reason why it's on Pepsi and 7-Up and Kleenex, even though you know that they're registered trademarks, is because it's just back to the point too, is you're announcing to the world, this is mine, I don't want you to steal it. And so, the best advice is put it somewhere where they'll find it, but it doesn't have to be peppered all over the item that you might be designing.
Okay, good.
Oh, good to say.
Good boy. Okay, that's good.
Yeah.
All right. So what's your third mistake?
Okay, so we hopefully Josh convinced you that not filing is a mistake, but there's also an issue about filing too late. There's a lot of misconceptions about timing with trademarks, and there's also a bit of a chicken egg problem because you can't get that certificate until you actually have use in interstate commerce. What does that mean for CPG brands? Usually, it means you've actually sold something in another state. From where you're located. I also can mean transporting and things, but you gotta really have a real product, okay? This isn't, it's not okay to just have a launch page. Well, I've got my website set up and I have my social media and there's some great pictures of, mock-ups. That's not gonna fly. So then people say to me, well, okay, well, if I have to sell something to get a trademark, like, how's that even possible? Because I want to know my trademark before I invest in the packaging. This is something I've spoken with you guys a lot about too, because as you're helping people do like high-end nice packaging, they don't want to make that big investment. So one timing strategy is certainly you don't have a product on the shelves before you at least do a little bit of a risk assessment search, like mistake number one. File, mistake number two. But then you have to wait. Okay, you file what's called intent to use, meaning you're holding your place in line. And then the government used to take like 4 or 5 months. Now they're at like 8 or 9 months, which is very frustrating to me and to the clients we work with. But during that window of time, that's the sweet spot for CPG brands to actually start selling. But what about the fact that it's not done yet? You can't use your R in a circle. Maybe you're going to get a refusal. It happens sometimes. There might be something that comes up. And my answer is get started. Maybe don't make your full investment in packaging. And have this sort of, first edition of something, and then and put the TM on it. And then after, then your next, not your final packaging, because that always changes, right? But your bigger investment will be after you have your registration. But the mistake I'm talking about is filing too late, waiting until you've already sold. That's a dangerous path because it's a first to file system here, essentially a first to file system in the United States. There's some exceptions. But if you wait, and as we know, people have an idea and it takes a long time to get it on shelves, and even longer to get it on shelves. You can get it maybe to the farmer's market, which is an awesome first step, but to get it to get it in distribution in another region through a distributor takes a long time. So during that period of time where you're out there, you're on social media, people hear your name. If you haven't filed yet, you're in serious danger of somebody filing before you.
Yeah.
Because now you're putting that good idea out there. You came up with a great name. Everyone's hearing it. Wow, that sounds cool. Let me see if this is registered.
That's right. Even subconsciously, right?
Yeah, I know. It's always our concern. Like, I never want to get started on a brand unless I know they have it registered.
Procedurally or sequentially for us, it's tough because we've been there where we got halfway through and then with change the name. Well, these sketches are based on the name.
That's why the search, even though no search is guaranteed, you have a good sense of the prognosis. It's a real shame to kind of quickly move forward with that investment before doing that research, because it'll get you every time.
Yeah, it's so funny. Like even a couple times, like one client had been in business for so long, a meatball brand that we've been working with, and the guy had been in business for years, and we're like, well, of course he has a trademark. We asked him, he said yes, like no problem. And then we got into him, we're like, oh,
there was something very early on. We're like, oh, there's that name, but
the
that's
Spidey
fine.
sense was going, and I didn't listen to the Spidey sense.
Well, it mentioned in passing, and then like 3 months later, we're like, wait a minute,
hold on,
you didn't register this?
Yeah, and then we call in a panic to you, Susie, in charge. And we're just like,
yeah, it can happen. It has happened.
yeah. So, okay, this is awesome. So, what's your fourth thing that you guys see?
The fourth thing we see all the time, and everyone experiences it when they have a registration, is a scam. And we do our very, very best to help everybody not get scammed. But boy, the people
I try to tell people in the email at least like 3-4 times.
They're getting, the scam artists are getting smarter and smarter. And so, one of the ways you may have already experienced this is a lot of, our clients own domain names. They've owned domain names well before they had a brand of something. And, 10 months into the domain name, they get a letter in the mail from some domain registrar that looks really official from some governmental agency. Yeah, I can see your faces. You're like, yep, I know what you're talking about.
We get 2 or 3 of those a year.
Yeah, and it's like, your domain will be forfeited if you don't send us $437, and
and 22 cents. Yeah,
it's all, and so I want to use the word scam loosely. Presumably, if you send money to those places, they will actually follow through and do the registration for you and the transfer and make sure that your license is still good or your registration with your domain is still good. But we don't know because we would never recommend someone go through those companies. You should actually go to the source. And the same thing is true with USPTO trademarks. And so, they're good for a certain period of time. And, it used to be, maybe a year before you could register it, you would get a letter in the mail from some scam artist.
We're talking about renewals.
Yeah, renewals.
Oh, renewals is the
are,
scam bit.
Is
Renewal
that
scams.
Suzanne? I believe it's 10.
Can you say it again?
Is it 10 years for renewals?
So there's an initial check-in, a statement of continued use between the 5th and 6th year. And then the renewals are in every 10-year mark. So between year 9 and 10, 19 and 20, etc. But the scammers usually send the renewal notices more than a year before the initial window opens. And they start with trademark cancellation notice. And then, then the person will call me if they don't realize it's a scam and say, my trademarks have been canceled.
And despite our many, many, many warnings, our many continued warnings, we have had clients who have fallen for those. And
really?
Yes.
It's really legitimate. They come from places called Patent and Trademark Office. Like they have names. And of course you're saying, how can these places still be in business? And the answer is they keep getting in trouble, they keep shutting down, and they keep reopening from overseas places.
It's exactly right.
So there's like US
other scams too that come even like a few months after you register. There's one like, you should be in the world database of trademarks. And it's $1,000 invoice that my clients say, like, I thought I paid you. What is this? It's heartbreaking. Actually.
Anything that comes in the mail, anything that comes from email, if it's not from your lawyer, call your lawyer.
That's right, because your lawyer is the correspondent officially.
We will never charge you, and hopefully your lawyer wouldn't charge you for a call or an email to say, I got this in the mail, should I pay this? The answer is almost always going to be no. We will handle these things for you. You'll pay us and we'll take care of it, and it will almost assuredly be a fraction of the price that you received in the mail. So that's very, very important.
But just related to that, it didn't make the top 5, but related to not falling for things is making sure that you're doing your own docketing, meaning the date of your renewal and you put it in your own calendar. Technically speaking, your trademark lawyer no longer has power of attorney after your registration issues. Now, a firm like ours puts it in our docket and we send courtesy reminders, but technically speaking, we're not on the hook. So you get a scam, you fall for it. It's really unfortunate. Put the correct date in your own calendar, please.
Yeah.
Okay? So if something happens, let's say you fall for a scam, you're not losing your trademark or patent, your copyright. You're just mostly losing money, right?
And most likely, we're not aware of every scam that's out there, and presumably there are scam artists out there who actually will send a letter, get your $750 check, and do nothing.
More than that, yeah.
And $1,750
scam.
Do nothing, and your renewal window lapses, then you're in real trouble. So it's important to make sure that, the appropriate filing gets taken care of at the USPTO, which, you can do, your lawyer can do. But yeah, don't fall for the scams, no matter how official they look.
Man, it's so funny.
But
like
they use Times New Roman.
Yeah. Like,
There was a wax seal on the back of the envelope. Like, how could this not have been legit?
It's embossed.
I know. I know we've definitely like gotten fishy stuff like
We've
that.
had a few.
And of course, I'm always the one that's like, oh, what's the problem? And you're like, Katie, what the hell? Every time.
The website, I'm like, no way.
The scammers are good. They are good. That's why they keep reopening. They're making a lot of money.
And we see these all the time. Every now and then we still get them. We're like, wow, that's pretty good. That's pretty good.
Really? Wow, they're pretty sneaky, huh?
Yep.
We were thinking of actually going into business as scammers instead. What do you think?
Our next life. Yeah.
Next life. Oh my gosh.
Well, are we ready for number 5?
Oh yes, and I know drum roll here. I don't know if we went in order of most, but yeah,
Pretty close. Yeah.
it's a good one. It's a good one that has to do with policing your mark, which sounds pretty scary. So okay, the mistake is not policing your mark. So let's say you've done all this work, you've worked with an amazing design firm like Fizz, you've got this cool packaging, you've got your registration, you're out there. And then you notice, or someone tells you like, hey, I was at the store and I saw this brand and it sounded kind of like ours. And you say, oh, I'm not going to worry about it. They're kind of a mom and pop. I'm just going to let this one go. So the idea here is we help clients with this, which is keep an eye on what is happening. Now, there's the informal way of, obviously, when you go in the stores, you should always be aware of brands. There's things like Google alerts, which you can set up on Google, and they're free. And you can see anytime there's a mention of a brand, and you might want to type in, set up searches for lots of variations. But also, attorneys have access to systems where every week we can run reports of things that are filed that are similar to your filings. And like you may choose to ignore them, but the problem, if you keep ignoring things and things get registered, eventually something's going to really bother you, right? And at that point, Josh can kind of explain, it's sort of like you've waived, like it's this idea of, it's a problem in litigation because
it could be assumed as a waiver. And so if there's something that's close to you, and you let it go, and the next thing is close to you and you let it go, and the 5th and 7th and 10th thing you let go, when the 11th thing, it's almost like maybe like death by 1,000 cuts, once it really matters to you and you try to go after them, the other side will have a really good argument and say, why us? Why are you selectively enforcing this on us? There's 10 other people that came before us that you didn't have a problem with. And so you lost your right to complain. And so, we give advice regularly about which battles you should pick. And so when you have a question about, is this too close? Is this the thing that I should worry about? We're always going to defer to the client. It does, if it's something that you care about, we're going to care about it. We're going to give you advice on whether or not you have a right to pursue after that. But there are some things where even if our opinion would be, it's too close. It deserves at a minimum a letter. Whether it's a cease and desist letter or a, hey, we're aware of you letter, and we want to know what your intentions are for this, because, if you didn't know about us, now you do, and it's a little too close to what we do. And because again, if you don't do those things, it may bite you in the butt at the end of the day.
Yep.
Yeah. And we've been through part of this process with Suzanne years ago. We had someone, same name, same color scheme, similar logo on the website.
Yeah, they had like the little, like our old brand was like the bubbles above the eye in the bottle and like the whole works.
And they had a lot of that on their site. It was Fizz Creative Media. So they added media to and had that URL.
Yeah.
So they took the full 30 days to take it down too. We give them a warning. And the whole thing. Yeah,
that was our kick in the butt to get our registration sorted. Thankfully, they didn't have it, so we saved it. Suzanne saved our butts, but geez Louise, that was scary.
They're also out of the country, so it's fun.
But the flip side of that is like with Fizz, if somebody has like a soft drink called Fizz, send them a letter. Like, not only are you going to be perceived as a bully, but be careful, because anything you write can show up on the internet. So I do try to help. We really don't want to work with bullies, and we really do try to help be selective about what's an issue and what's not.
Yeah.
And I think that's the important thing, like, you know, why you hire a firm like Suzanne and Josh is just because you may want to go after anyone and everyone, but they really can help you navigate like what's a battle worth fighting. You know, they can look up litigation of the other party and like a lot of stuff that the average person doesn't have access to. So
we're not just the average person.
Yeah. You are definitely not. You are above average lawyers for sure. So if people would like to reach out to you guys and engage your firm, how would you guys recommend that they reach out?
Well, we'll flash this information on the screen.
Yes, of course.
But you can go to our website, themoskowitzfirm.com, and there's the contact us form through there. It's a great way to reach out.
Awesome. Well, thank you guys so much for the time. It was so great to get all of your series of mistakes that you've seen people make. And hopefully our CPG brands will not make those mistakes. But if they do, they know who to reach out to.
Thank you so much.
I think so much.